Natalie and Lauren, thank you so very much for joining me today to talk about divorce.
A pleasure.
Yes, it's a pleasure. Thank you for having us.
I hear you guys are the experts in divorce here in Santa Clara County. And before we get to my questions that I have for you, would you mind introducing yourselves and tell us a little bit about you, like where you're from and where'd you go to law school and all that good stuff?
Sure. I'm Lauren Edwards. It's a pleasure to meet you, Sebastian. I born and raised in Santa Cruz. I went to San Jose State, and then I went to Baylor for law school, which was quite an experience going to tiny town Texas. And then came back after graduating because my family is here. Found my way to family law by accident. It was totally intervention, divine or otherwise. And happy to be doing estate planning, family law with some estate planning thrown in.
Oh, yeah. Great.
Yeah.
Right. I'm Natalie Gomez. I was also, not also, but born and raised in San Jose. And I went to undergrad at Cal, Berkeley, and then I went to law school at Santa Clara University. Funny enough, my counselor at that school at Santa Clara said, "Oh, you have enough to get a special interest in criminal justice." So I had enough units for that, but found my way to family law just from family and friends kind of asking questions about it, and me having an interest in resolving disputes.
Oh, right on. Well, I'm from Berkeley, California. That's my hometown. So go Bears.
Yay, go Bears.
So how long have you been practicing family law here in Santa Clara County?
I've been practicing since 2012, June 2012. So that puts me right at about 12 years.
The anniversary.
Correct. Yeah, and Lauren is right after me.
Yep. I started practicing in February of 2015, and then we've had our business together since January of 2016.
All right. So between the two of you, like 21 years of experience that you're bringing to the discussion right now.
Sebastian, that's so scary.
Good. I'm sure you guys appreciate that.
Yes. Thank you.
All right. Well, my first question is what's the grounds for divorce in California? Like, what do you need to, tell the judge or whatever in order to get a divorce granted?
Yeah, so luckily in California, we're really lucky to be in a no-fault state. So all you have to do is tell the judge that you have irreconcilable differences and that there's no services that the court can provide to you, such as therapy, counseling, anything like that. And as long as one spouse says this cannot be fixed, I want out, the judge will grant your divorce.
Oh.
So we're a no-fault state, which is great. Other states, you have to actually prove up before you can even file for divorce that there's ground for it, but not in California. Just
how about Texas? Texas, is that a?
Yeah, so Texas has no fault, but they also have fault. And so if you have a trial saying that there's fault, depending on the outcome, that can really impact what the overall outcome of the divorce is. So it's going to look one way if it's no fault. It's going to look a different way if somebody's at fault.
Interesting. All right.
And that's exciting because our Lauren Edwards is also barred in Texas. So I'm glad she's able to comment on that.
Oh, you are? Interesting. Good to know. Good to know. All right. So let's just say you unfortunately do have to get divorced and there are marital assets. How are those generally divvied up? Is there a formula or how does that normally work?
So in California, generally the marital assets will be subject to a 50% division. It's an equal division. And like Lauren mentioned, as Texas and other states, they do kind of a proportional or they have different analysis. But here in California, the presumption is that it's an equal division, subject to other family codes that provide for a different type of allocation. And so some of those could be what we call the Family Code 2640, which is if someone has a separate property claim that they brought to that asset, they are supposed to trace that and have documented evidence for that. And so, for example, let's just say we're dividing a home, it's valued at $100,000. I'm just using round numbers here. We know that's not the case here in Silicon Valley, but say that a spouse traced $50,000 of the deposit and they can show that they had that before marriage, then they would get that back to them and not divided. And then the remainder of any profit from the home will then be divided. And that's just the home. So 50-50 split unless you're able to prove otherwise through code and statutory code. So,
Okay.
The great thing about that, though, is that it's the value. Both spouses need to walk away with an equal value, a 50-50 value. But that doesn't mean that they both get 50% of the house. That doesn't mean that you're cutting pans in half. It's just that both spouses are walking away with an equal value, which makes settlement and negotiations and other things really fun, because you can find creative ways to get to that equal value, but allows one spouse to retain assets.
exactly.
Right. Interesting. Yeah, there's value and then there's cost, I guess.
Right.
Or
Right.
Price.
Right. Price, which
All
gets
right.
at
So how about spousal support? How does that work?
Ooh, spousal support is fun. So there's different types of spousal support.
Uh-oh, you're breaking up.
Oh, you want to try?
Sure. Can you hear me?
Lauren, okay. Lauren, hold. Yeah, Natalie, you're still there.
Okay, I'm still there. So what she was saying was spousal support is a fun issue, a very interesting issue for a better term. There's different kinds. There's temporary spousal support, and then there's permanent spousal support. And so California defines essentially temporary support is awarded to a marriage that's less than 10 years. And so permanent spousal support is for a marriage that's 10 years or longer. So that's a long-term marriage. And the calculation of those are very different. In California, there's a guideline support that the legislature has made up, and you put in numbers. What are the gross income? What are deductions? What are contributions to 401k? I mean, there's about 30 plus inputs that you can put into this DISO master calculation that will basically give you a temporary spousal support number and child support number. And permanent spousal support has to go over what we call the Family Code 4320 factors, which is more of an analysis of A through, I believe, N or so factors, which are age, health, ability to work. So it's not a calculation. It's something that we look towards other experts to value what all those factors would bring into what a final permanent spousal support should be. And permanent is per the code, until death of the payee, and it could go towards the estate of the payor. So that is something that's a possibility as well. So lots of factors that go into a spousal support analysis, whether it's temporary or permanent.
So when we're talking permanent, does that mean till you die permanent, or what does that mean exactly?
That is what the code says. It is until. So it's really, I mean, you read the code and it is definitely frightening to read, but it doesn't mean that it's not something that can be requested to be modified if there's a change of circumstances. There's different rules about when you can modify a support order, and that can be an entire session of an hour plus itself, because there's different rules on where the case is at. Is it pre-judgment? Is it post-judgment? How was the order brought about? Was it through a contested hearing? Was it a stipulation? But yes, to answer your question directly, it is permanent, will be until the death of the payee, right? Mm-hmm. Unless the stipulation or the order says otherwise. There are lots of times where we've had cases that we've put kind of a deadline, an end date for support.
Or remarriage.
Yeah, or a remarriage. So if the payee is remarried, the code allows for that to be a terminating factor.
So if you're like 50 and you get divorced, you could be expected to be paying for 35 years until you die. Spousal support, is that common?
It's possible. So if the income changes, which I'm assuming it would after retirement, right, that would be a reason to modify, and the court takes that into account, then it would be modified to be reduced. And so a lot of times spousal support is an issue. The court wants everyone essentially to become self-supporting. So it is something that is kind of modified with the court and monitored, as long as the parties are pursuing their rights to do that. So a lot of times they're not always permanent. They are modified to say, hey, you're now self-sufficient, and there's no support needed. But you kind of have to go to the court and ask for that affirmative relief. Otherwise, the order is an order until it's modified.
Right. So if your income changes or your spouse's income changes, you could get that modified.
Correct.
How long does that usually take? Is that like a 6-month process or like 6 weeks or what does that take?
I appreciate your question. That's going to be a different answer for every county. We practice across probably all the counties in California. And so it really has to do with the court's calendar. So it can be a modification that we've made today's date, and we're going to have that heard in 35 days. And it can, if we have everything prepared and ready, the order's changed. If there's disputes and issues of discovering what the true income is, and everybody's asking each other what we call discovery questions, it can take months. We've had some that, in our experience, have been very highly contested, and it's been probably years where we actually had the full trial because there was continuous discovery motions before that. So I can't give you a straight answer, but it could be as quick as within 35 days or years.
So you have a trial to change the spousal support.
Right. And they reserve retroactivity to when they filed that request.
Wow. Wow. Well, okay. So what are the steps in the divorce process? Say I want to get divorced. What do I do first? And walk me through that.
Sure.
Well, I guess the very first thing is you have to decide what type of divorce you're going to have. So there's traditional route, which is you're going to court, you're both having your own separate lawyers, you're proceeding adversarially. Then there's also the option to proceed with mediation, or there's the option to proceed collaboratively. So first you have to decide what type of divorce do you want to have. Then once you've made that decision, somebody's got to file a petition. Somebody's got to file a summons to start the case. And it doesn't matter. Even if you're going through mediation, you have to have a case started. And in California, you can't have a judgment until 6 months and 1 day after the service. So if you file a petition in January, but you don't serve it till June, the soonest you can get divorced is December. So that waiting, it's really important. That's what starts the clock. The other side has to decide if they're going to respond. Not everybody responds. And you have to decide if they don't respond, are you doing a default? Are you doing mediation? So there's lots of variables that changes every case. And then you have to complete your financial disclosures. That is mandatory. It doesn't matter if you guys say, I've got one credit card and one bank account. Everybody has to do disclosures. A judgment will not be granted without them. And then from there, it's really looking at what are the issues. Are there children? Do you need a parenting plan? Do you need to figure out child support? Is it a long-term marriage that needs permanent spousal support? Is it a short-term marriage? Do the parties have disparity in access to funds, or are they pretty much equal in terms of their income and access to funds? So we've had some divorces, we've had some cases where they come to us, it's a mediation, they know exactly what they want in the first week, and it's just a waiting game for that 6 months to pass. And then we've had other cases where it's been 8 years and they're still not divorced. So it really, while there is a general trajectory, it truly does look very different for every couple going through a dissolution.
Right. And the summons, petition, those forms are required. If there's children, you have the child forms that are required that have jurisdiction over the children. So there's about at least 12, I would say, mandatory court forms that have to be filed in order to kind of proceed to judgment. And a lot of times or individuals who represent themselves don't understand that procedural requirement, and they're kind of stuck in this no man's land where their divorce is really never finalized.
Right. So you mentioned mediation. That is not handled by attorneys, though, right? That's like a separate process, right?
It absolutely can be. So there are mediators who have never gone to law school. There are mediators who are really just there to help people work out an agreement. And then you have people like ourselves who we love settlement. We love helping people avoid, this is a big word, but the trauma of going to court and of having a person up on a bench who doesn't know them in a black robe making decisions about their life. So we absolutely, attorneys can serve as mediators. And the best thing about an attorney serving as a mediator is we can also prepare the forms and the documents. If you get a mediator who isn't a lawyer, then you typically have to hire a lawyer separate from that to prepare the forms, because it's fraudulent practice of law if a unlicensed mediator is preparing legal forms. So you're going to have to get a lawyer involved at some point to make sure that, because judgments will be rejected. There are certain provisions that are required in marital settlement agreements. And if a judge looks through it and says, you haven't addressed Family Code 4065 and you haven't addressed all these different things, they'll reject it and send it back to you. And let me tell you, that's an annoying process because it takes like 3 to 4 months to get the judgment looked at. And then you get it rejected, and then you've got to figure out how to fix it, and then you've got to submit it and wait another 3 to 4 months to have it looked at. So having it submitted right the first time is really important to help with that.
Right. And I appreciate your question. Just to add a little bit about mediation, we do have a lot of mediated cases. And like she said, we're helping both individuals kind of navigate the forms and their agreements. And the way that looks like is they have their own names on the caption versus our office as a caption, because we are essentially mediating the whole case with them. And as Lauren indicated, in order to be a mediator, you're not necessarily required to have a JD, a Juris Doctorate. So we take cases across all 50 states because mediation is mediation. It's about not going to court, not having that litigation and adversarial part. And so we can represent people throughout all 50 states. It's just lucky that we are attorneys. So once we get it in California, we are able to get the forms processed for them.
Oh, wow. So what percentage would you say of your California domestic business goes to court versus mediation? Is it like 50-50 or is?
I would say it's probably closer to like 70-30. We do have a lot of clients who come to us and then halfway through they realize, I mean, I'll just be direct with you, litigation's expensive. Because next thing you know, you've got discovery, then you're fighting because you're saying that, well, they didn't give me these 12 bank statements, and then your subpoenas, and then you're having all these hearings that have nothing to do with the substance of your case. So in a traditional route, it is very easy for costs to all of a sudden blow up overnight. And so we will have clients who come to us where they're in the middle of these disputes and they're like, we've got to stop the financial hemorrhaging. We've got to figure out a way to pump the brakes. Let's come back. Let's figure out how to resolve this. And so, yeah, I'd probably say it's about 70-30.
So what's the difference in cost between mediation versus going to court? Is it like 10% to get mediated or?
Yeah, I mean, I would say it's pretty dramatic, the difference. There is still one of the best things about mediation or collaboration is that your lawyer, it really becomes a part of a team. And so you have access to other resources that don't necessarily apply in litigation. So we will recommend in particularly difficult mediations, we can recommend that people with children talk to a child specialist. And so they're working with somebody who is uniquely trained to support parents as they transition to a co-parenting relationship, understands the needs of their children and how their children are going to react to a divorce. And so how they can craft a co-parenting plan that supports their child. You're not going to do that in litigation. So that's an extra expense because it's an expert that you're jointly working with. But overall, you're not having a custody evaluation. You're not having a trial. So you've potentially saved $50,000 by working together with a co-parent, with a child specialist.
Oh, wow. Wow. Okay.
Yeah.
Speaking of children, how is custody determined in California? How does that work?
Yeah.
So custody generally in California, I would say that the California judges, or here in Santa Clara, are really wanting to have the best interest. They have the best interest of the child in mind. And, you know, research has shown having both parents involved is really what's best, as long as there's no harmful or abusive conduct by one of the parents. So I would say that it's generally leaning towards having like an equal type of parenting plan and joint decision making, subject to any person having proof that, you know, there's domestic violence or there's a reason, a substantial reason why a parent shouldn't have like a joint custody or a equal parenting time. And so then that's when you get your domestic violence cases and or, you know, parental abduction type cases. But I would say most of the courts, well, California has a couple of systems. The Santa Clara has a mediation. So they have to go to mediation before they have their custodial hearing. And it's confidential. So if they resolve it there, then that person who helped them at the court it's a court mediation, will draft up the agreement. Other counties, such as like Alameda County, is called recommending county. And so that's not confidential. The parents will speak with that mediator there at the court, and then that mediator is going to make a kind of a recommended order. And then the judges, generally, again, absent any other evidence, will adopt that agreement.
Okay. All right. So, what is the difference between like a divorce and like a legal separation? Is there any difference between those two? I mean, I don't know what those mean. How's that work?
Yeah, so there's a really big difference. So with a divorce, you are ending everything to do with the relationship. With a legal separation, and sometimes this gets used incorrectly, a true legal separation has a judgment where you are completely separating your finances, but you're not dissolving the marriage. And so it can be a really important avenue for somebody who, let's say that they're Catholic and their religion does not allow them to get divorced, but they don't want to be financially tied to the other person. So they can separate themselves. They can choose to live separate and apart. They can have separate finances, all of that, but then they're still maintaining that marital status. And it often is used in that specific example where for some reason there's religious beliefs or some other kind of family pressure to where it is, for lack of a better word, shameful or not allowed to have a judgment of divorce.
Or some individuals, let's say it's a dissolution and they're in their 80s and they've decided they still want to file taxes together and they want to stay on each other's health insurance. Health insurance isn't changed or dissolved if it's a legal separation. Those things stay in place, but everything else financially is divided. So a divorce terminates the legal marital status and therefore becomes a terminating factor for health insurance, and all of that is able to be taken off and ends as well. And so I'm glad that you say this because I actually had this come up. It's also different from your date of separation. And so in California, you have a date of separation. Lots of individuals basically think that's the date they're legally separated, but those are very different terms. Your date of separation is essentially when you've informed the other party and you both are aware that the marriage is over. And so the court is using that date to kind of draw a line in the sand through the divorce, but you still have to wait to judgment, whether it's legal separation or divorce, to get your legal status returned to single.
And so if you are legally separated, you would still then have alimony and child support and all that other stuff.
Right.
Right. Okay. So people mostly choose to get legally separated really because of religious reasons or practical purposes like insurance and stuff like that. But effectively, it really is basically a divorce.
Right. With the finances, yeah, those are still being divided.
Okay. So what does somebody do if like their ex-spouse is not like living up to their obligations, like they're not paying alimony or child support, or what other things might they be bound to do by the court besides pay alimony and child support?
Oh, well, a really big one, and this happens all the time, is not complying with the terms of the marital settlement agreement. So for example, dividing retirement accounts or selling a house and completing the buyout of the house, completing the buyout of a business. It is usually financial in nature, although there can be failures to comply with the judgment or the orders about timeshare. And who's responsible for picking up? Who is somebody keeping the children too long? Is someone not showing up to their visits and letting the other parent essentially have all of the time and they've just kind of washed their hands even though they have an order? But there are a unlimited number of ways to not comply with orders and judgments, and you'd be surprised at the way people find to not follow through.
Yeah. So the relief essentially is you have to return to court. You're either filing a contempt motion, which can sanction that party, but those sanctions and contempt don't necessarily go towards the person. There's different sanctions you can ask for. So if the court imposes sanctions via contempt, it's kind of a civil, criminal, quasi-criminal. And then you would have to ask for your own sanctions individually in your motion. And so there's, again, various different kinds that you can ask for. And in just enforcement, your motion would be an enforcement of the terms, recalculation of what monies are owed. The banks can, not the banks, the courts can issue a levy on the bank if child support is involved, Department of Child Support Services. They can divide assets proportionally and say, look, you owe this much, so they're going to get more in this account, or more in proceeds from the home. So there's different ways to seek relief and enforcement.
Another really important thing to note is that spouses, from the moment of marriage until the moment the judgment is fully complied with, have spousal fiduciary duties to each other. And so if you have a judgment, if you are considered divorced, but you have not followed through on the judgment, your fiduciary obligations are ongoing. And so not only is there an enforcement of the judgment because you failed to perform, but there's also the fact that you now have, on an ongoing basis, been breaching your fiduciary obligations, which comes with its own implications for financial consequences. And so there can be additional sanctions on top of an unequal division of the property. There can be additional sanctions. The judge can order the violating spouse to pay the other spouse's attorney fees if they prevail. So there is a whole host of issues if you're not complying with the judgment.
So the judge could order the sale of the house and basically give it to a receiver, or like who gets it at that point? I mean, it goes in receivership essentially, and like stocks and any other assets, they could basically just take it from you.
Right, as long as they are subject to community property division.
Right.
So when it's separate, so there are times where they can go into separate property, but that's a whole nother issue.
Right. Okay. So we talked about the assets. What about like the debts? Like a lot of people have a lot of debt, right? Like I don't know, tax debt, or credit card debt, or just personal loans. Like what happens? How does the debt get split up?
Yeah, so debts, again, those are also for the most part equally divided as well. So you'd have to prove with sufficient evidence that perhaps a debt was not for the benefit of the community of the marriage. A lot of times that's for gambling or something like that, or perhaps
a paramour that you're taking on expensive vacations or buying jewelry for.
So you'd have to. Well, yeah.
But the thing that is surprising to most people in a situation where there's a lot of debt is how gracious the court is for what qualifies as benefiting the community. So like, let's just pick on women for a second. If a wife has a credit card that is only spa days, haircuts, like elaborate manicures, the court can look at that and say, yeah, but happy wife, happy life. She was taking care of herself. She's benefiting herself. That means she's going to be better at home. Okay, you didn't know about it, but that still benefited the community because she was taking care of herself. So there are definitely times where the division of debts is upsetting because somebody doesn't agree with how money was spent. But again, with that very broad definition of benefiting the community, the judge says, but it was for the community.
So let's just say there's like a personal loan for 50 grand. It's made in one party's name, but they both spent it. And after the divorce, the debt doesn't get split in two, does it? How does that work? Like, you refinance it, or how does that work from a practical standpoint?
Well, from just the example you gave us right now, you said it was in one party's name, but they both spent it. I think that's going to be the underlying factor for the judge, right? So the judge may say, well, you both spent it, so it did benefit the community, and I'm actually going to assign this to both of you. Because you have to remember, when you're married, and if there's no prenuptial agreement, even though you are going to obtain a debt that's in somebody's sole name, it's incurred during the marriage. And so if it's during the marriage, it's going to be presumptively labeled community property.
And that actually trips up people all the time because it's true for property, for assets, and debts. So somebody will say, and this happens all the time, the bank account's only in my name. And it's like, okay, but were you married when it was opened? Yes. All right. Did you have a premarital agreement saying your property in your name is yours alone? No. Were you putting community property into the account, your community income? Yes. That's a community property account. So the title alone does not dictate the characterization of an asset or a debt, which really trips people up all the time.
But if one party has the debt in their name, how does the other person assume half the liability for that debt? And then, do you just refinance essentially, or how does that work?
So for a home, for a home, it could be a refinance. It could be essentially a buy, like let's say the person's buying out their interests of the other parties in the home. And so then we would calculate what that buyout number is and take that number into account. So then that debt will remain with them while they paid the other interest out as the buyout. For credit cards, it would just be they need to work together to switch names. If they've assigned a certain debt to themselves, husband or wife, they need to allocate that and make sure that they do all of that. So it's really on them to, in good faith, change whatever needs to be changed so the debt is in their name moving forward after their agreement.
And tax debt, would the IRS then, like if they were married filing jointly and then they got divorced, would the IRS then split that debt in two separate accounts? How's that work?
So the IRS is its own entity and they don't care. So they're going to take money from whoever. So it really goes back to your agreements and if there's a judgment. So if you have assigned those either 50-50 or if there's an agreement because there were buyouts 70-30, whatever it is, that agreement needs to be detailed in the marital settlement agreement and in the judgment. And the court expects them to pay that accordingly to whatever percentage they said. So you're right. The IRS is not going to be like, oh, okay, here it is. I'm just going to ask them for half. No, that's not going to happen.
No.
Or 70%. No, it's up to them to do it. And if they don't, then the person who is harmed then has to come back and ask relief from the court to say, look, yeah, our judgment says I was only supposed to pay 30%. I've paid 50. I need a reimbursement.
Right. Okay. All right. So how about hiding assets? Do spouses ever trying to hide assets? And what do you do if your ex-spouse is hiding assets? Is there any way to get them uncovered, or how does that work?
Hidden assets are very difficult because there's a range of sophistication in hiding assets. So some people are very sophisticated and they've started a long time ago and there's no paper trail, there's no transfers between accounts. And then there's the less sophisticated people who 6 months before they know that they want to file for divorce, they open a new account and they slowly start making transfers over to it. So it really depends upon the sophistication of the party as to how difficult that is to navigate. In most instances, the best advice is to get a forensic accountant who this is what they do day in and day out. They look at financial statements, they look at transfers. There are cases where we're just sending blanket subpoenas to all the major financial institutions, trying to see if we can find any assets that belong to that individual. Because again, depending upon the sophistication of the party who's hiding assets, it can be incredibly difficult to find them.
And it's difficult for the person wanting to find it because say they don't have a lot of assets to spend for this in-depth investigation. And so really have to kind of analyze, the cost and how many assets do you believe are missing. But in every judgment, I believe people need to include, we include language for omitted assets. And so if it's ever found out after the fact, that provision is going to state that the court still retains jurisdiction to divide that asset once it's found. And if it's found to be maliciously hidden, there's certain codes that allows the court to award that asset entirely to the person it was hidden from. So there are codes to help prevent that and deter that with different types of allocation.
Well, that sounds really expensive. So blanket subpoenas and forensic accountants, like how much might people spend? Tens of thousands of dollars, it sounds like.
Yeah, probably more.
Yeah.
Really? Wow. How often do you come across hidden assets? Is that common or not really?
It is a very common allegation. But I would say it is not so common to actually find out that the allegation is true.
Right. Okay. So how about like tax implications? Are there any tax implications at all for divorce, or how does that come into play?
Yeah. So luckily, pretty much all transfers incident to a divorce by the IRS code are done without tax implications. So you're not making, it's not a gift of property. You don't have to worry about the gift tax exemption. You don't have to worry about any of that. It just needs to be clear in the paperwork that you are doing a transfer pursuant to a dissolution judgment, and then the tax does not come into play.
But of course, we always have to let our clients know to consult a tax professional because we are not that.
Yeah.
Right. Well, but what about debt, right? So there's debt relief is taxable, right? So if your spouse agrees to take on debt, does the other person then have a financial penalty for debt relief, or no?
No, no. And a big thing with when there's an assumption of debt, what typically happens is we're talking about that equalization and that allocation. So somebody is assuming more debt, but they're also typically receiving more value from property in order to balance that out. So Natalie made a really good point. We do always recommend, as we're preparing MSA or marital settlement agreements, that the CPA is consulted with, that the person's tax professional is consulted with. But as a general rule, there are not going to be tax implications.
Okay. So this is just kind of a broad question, but like, what are people most surprised about the divorce process?
I think how long it can take. People hear 6 months in one day and they're like, okay, this is going to be great, easy, breezy. And it's like, but it's not really. So I would say the length of time is definitely a big one. I think people are often surprised by the complexity and the fact that they have to do disclosures, because people will come to us and they're like, but we agree. We only have 3 things. We know what we want. And it's like, yeah, but the judge is going to deny your judgment unless we do this. And so there can be some surprise at the duration, but also the complexity of the forms, certainly.
Yeah, that are required.
Yeah.
And then honestly, I think the third one that is always an unknown is the cost, right? The fees. And so I know you asked about fees earlier, and it's, if you think about it, attorneys' fees, they're vary, right? They're rates. But if you're talking about a case, it probably is going to take at least 10 hours to kind of go through everything. If it's very simple, I would say that's probably the minimum number of hours that would be worked on a case. If it was simple, shut and close, and we're good. But then you're talking about custody, let's say custody disputes. You can have 10, 20 hours in 1 month for 12 months. And so if you're thinking about the rate, let's just say that's going to be a difference of between like 7,500 to, 6 digits. So.
Mm-hmm.
Wow. Yeah. So are these cases always billed per hour, or are they ever like a fixed fee, or are there any other structures that are used?
So family cases are statutorily prohibited from being contingency. So you cannot do a family law case on contingency. There are attorneys who will do like package flat prices for uncontested, but it is very easy to think that you have an uncontested divorce and then to 6 weeks, 4 weeks, 8 weeks later find out, oh no, this is definitely going to be contested. So we do all of ours on an hourly basis. But one of the things that we do in particular, and I don't know if this is common in the industry, but a lot of times we will offer consulting services. So we are happy to be in the background. We're happy to provide advice and guidance, help people prepare for court, but not necessarily be their attorney of record. Just because we do think it's really important for people to have access to counsel that isn't necessarily waiting in a long line at the self-help center. The self-help center is wonderful, but sometimes people need faster information. So we do consult with people to try and help provide that service to people who otherwise couldn't have access to it. But yeah, I think it's pretty standard for an hourly rate.
Okay, well, that's all the questions I have, but are there any questions that other people ask you that I maybe should have asked you but didn't?
Oh, that's a great question. We get this a lot, and we get it from men and women about people asking if the court is more favorable to moms or dads. We get that all the time. We get it from both dads and moms about, well, isn't one spouse going to be the priority for staying in the home with the kids? And it is, I would say, across the board, there is not a preference. In our code, there's no preference. There used to be a preference for mom actually in the code, but there is none of that anymore. And in fact, I would say it's actually, in my experience, the judges seem to protect dads in the sense that there is a perception that mom is going to be favored. And so judges seem to be very overt in saying, no, you're both here in front of me. You both get equal consideration. This is really important for your child to have access to both of you. But I would say there are definitely gender concerns about how the court will favor individuals.
Yeah, that is definitely a
Are
lot.
most of the judges men or women? What's the breakdown between men and women judges in family law? 50-50.
Yeah, so in Santa Clara, this isn't true in every county. So the answer to that question is really dependent upon the resources of the county. So in Santa Clara, our judges rotate about every 1 to 2 years. And so there are times when we have significantly more male judges because of the rotation, and there's times when we have more women because of the rotation. I would say in general, it does seem to feel pretty equal. I do think right now we have more women than men at the moment, but it really depends on the cycle of judges. And the goal in Santa Clara is that every judge knows how to manage every single assignment. And so that's why they cycle them through. But if you go to a county like San Benito, where you only have 2 or 3 departments, each judge every single day is responsible for a different calendar, and they may only ever have 3 judges, the same 3 judges in a 10-year span. So you're not getting that same rotation. So it depends on the county, the resources they have, their population, and how many judges are assigned to them.
Okay, interesting. All right, well, any other questions that come up that I neglected to ask?
No, I think that you're very accurate. Very thorough.
Well, I guess on property, very important. Inheritance or gifts are always going to be separate property. That's a question that comes up a lot.
Yeah.
The caveat to that is if you receive an inheritance and then you go and deposit that inheritance into a community property account, you've now lost the protection of that being your separate property. So, and we get that a lot with our estate planning clients because they're like, I don't like my daughter-in-law, my son-in-law. How do I protect this from going to them? And I'm like, well, once your child gets it, it's out of your hands. Just tell them to manage it properly. And then the other person won't have a claim to it.
Right. And so you have an inheritance during marriage, just make sure it stays in a separate account. So tracing, like I mentioned before, tracing is very important. If you can't trace it and it's too commingled, that claim is gone.
Yep.
Well, what I'm taking away from all this is don't get divorced. Sounds like a really horrible process. And if you are going to get divorced, then mediation is definitely the way to go. And that sounds like you two would be wonderful people to help, married couples who are, looking at dissolving their relationship to go through this non-court process. You got me scared for anybody that is talking about divorce, because I work with people who are getting divorced, and I've never been divorced, so I don't really know what the process is like. But geez, it sounds like a nightmare, frankly, and that they really do need to talk to people like you before they even go very far down that path. It sounds like for some of those counseling sessions or consulting sessions.
Right. Yeah, that's great, and we do our best to make sure everything is amicable and as smooth as possible. And you're right.
I would give you one other takeaway, which is, and I know this is a controversial statement, but I love premarital agreements because you are, and I think a lot of people, there's this perception that you're jinxing the relationship by having a premarital agreement. But from our perspective, we deal with so many, well, I shouldn't say deal, but we work with so many couples who are going through divorce who they waited until they were in a bad place to have these difficult conversations. Whereas you're excited to get married, you love each other, you have a premarital agreement that's counseled by 2 different lawyers who are really helping you have these difficult conversations when you love each other. So that way, if the day comes and you decide this is no longer best for us to be in this relationship, you've already had those difficult conversations. You already know how you're dividing things. You already made these agreements from a loving place that make a divorce significantly easier. And premarital agreements are not foolproof. There are times where certain provisions can be set aside, and you can't make certain agreements, like you can't make preemptive agreements about custody, visitation, child support. But in terms of assets, debts, and spousal support, you absolutely can make those agreements, again, in a good place when you love each other, that makes the overall dissolution process significantly different.
Well, that is a good pro tip for sure.
Anybody getting married, tell them, think about a prenup.
I will be sure to mention that to all future people I know getting married. So how do folks get a hold of you if they want to, talk some of this stuff over? What's the best way to reach you guys?
Yeah, so we do direct people to our website. We have we use a program that's kind of like Calendly that people can set consultations through. We also, just calling our phone number, our main office line, our office manager, administrative coordinator. She is in charge of our calendar. She gets people on there. Her name is Katie Arnold. So yeah, just reaching out by phone, email.
Yeah, so
Easy.
the website's GomezEdwardsLawGroup.com. So it's
Okay.
Gomez with a Z, Edwards with an S.
Yep.
And our office number is 408-413-1200.
All right, terrific. Well, thank you both so much for your time. I know you're super busy, and I really, really appreciate it. And I know that people watching this are going to find it very valuable as well. And I hope your phone starts ringing even more after we finish this. All right, that's it. Thank you so much. We'll talk to you later.
Thanks. Have a great day. Bye.
Okay, bye-bye.